Justin Baldoni and Blake Lively trial gets postponed by 2 months. And did the judge imply he wants them to settle? Also, we got Ron Zambrano to talk about, did I screw up my case and miss filings? And could Justin lose his on Spoilation? You do not want to miss this one. Welcome to Popcorn Planet. I am Andy Signore. I'm here with Ron Zambrano. You're a fortune teller, Ron. You got it right. You should go get a lotto ticket. Welcome back to the show. How are you doing?
I'm doing great, Andy. How are you?
Good. I want to get through this because this news came in today. There was a hearing, and now the word's coming back that the trial's been postponed 2 months. It'll now begin instead of March into May, which obviously is a sigh of relief for me because it's prepping having to do this in March, and the documentary gives us a little bit more time to breathe. But you called this. This is not a surprise to you. But what was interesting as we go through all the articles, and I have a lot of questions, but there was one little part here specifically. Sources also are telling TMZ the judge ordered the parties to contact a particular magistrate judge for settlement purposes. What do you think all this means? What are your reactions? Let's hear it.
So this is a very normal part of the process from the judge's perspective. The judge is very incentivized to get cases off the docket and maybe avoid a large amount of work. As we all know, these motions that are pending before him are very, very enormous. But every single judge in the federal district and most judges in counties are going to tell the parties, listen, you guys have to try to go settle. Which is what the federal judge can do is he can order them to try to settle through the magistrate. So apparently there's a specific magistrate that either assists him or is in the pool of that he can ask to help him. And what will happen will be that both parties will reach out to the magistrate's clerk or courtroom and say, we've been ordered. Here's the order. When would you like to do? It's typically called like a settlement conference or a neutral evaluation is another one that they use in the federal district. And then they'll go through the process. Whether or not they're going in with actual intent to settle the case is another story, right? Like you could sit there and go, oh, I'm here because I've been told to, versus, hey, let's really try to reach a compromise. But the judge, at least Judge Lyman, wants to be told that process at least wasn't entered into. After that, he can't force anybody to do anything.
So this is all standard, is what I assume. Just because he's asked him to settle doesn't mean he wants them to settle. It just is part of the process, I imagine. Guys, make sure you've gone through this particular process. You've said it. Everyone said it. They should be settling at this point, it seems. Yeah. But do you think they will?
I don't think they. One of the egos has to be put aside to do it. So I just don't think they've put so much blood and money into this. I just don't see it happening. Someone has to win or lose, and it's going to be appealed. And we've talked about that already. I think that's what's going to have to happen.
Postponing this doesn't show any weakness on either side to you, correct?
No. So this was I think most attorneys that work in this space, New York or in the federal space, probably saw this happening. The shutdown for 42 days really impacted the courts all over the country. And the one thing that is not supposed to stop is criminal trials under the Fifth and Fourth Amendments. Every person's entitled to a speedy trial. So during the shutdown, if there was any slowdown in resources, it affected the civil docket. So the reviewing of all these things, everything had to be put to criminal trials. And so I'm assuming that backlog has finally been catching up to the civil docket for next spring. I'm sure this trial is not the only one before Judge Lyman and other judges around the federal system that are being continued.
Yeah, I mean, and shout out to docketupdates.com, who gives a lot of now good and up to date, because now it's still 159 days till trial. But the next part is this sort of the replied opposition for Blake Lively's tomorrow. It gives us all these deadlines. I mean, I guess what I'm bringing this up just because, like, what's next? What do we expect? They're saying that on January is when 22nd is when we'll hear oral and summary judgments, etc. So what does that mean? Like, when does evidence stop coming in? When do they start really prepping the main argument? What should we look forward to?
So there's two main things that are happening right now and are reflected actually in what you're showing. So the summary judgment hearing and also the motion for judgment on pleadings is after the reply is submitted for both motions, the court can do one of two things. The court can actually hear oral argument, or the court can say, I've got your documents. I don't need to hear from anybody. and then I'll call you, you call me. And then the other dates, the 23rd, the pretrial order, motions limine, joint proposal, all those things, Andy, that is so much work for the attorneys because they have to work together. They have to work. They have to work together to draft these forms to make sure everything is done on the 23rd. So not only are they working supposedly for oral arguments on the 22nd, at the same time they're really spending hours and hours of time with all these things that have been submitted, creating exhibit lists, creating witness lists, which might be you, Andy, creating
Oh, we're
trial.
gonna come back to me, but yeah.
Right. But I mean, that's how massive it may be. I mean, it might be dozens of people on these lists. There have to be estimated times from each side of examination. There have to be objections to evidence. It is so much work that is going to be in this particular party's January that is leading up to this. And the judge can go on the 21st going, everything's off. I'll call you. Don't call me. And when I'm ready to hear anything and put you really on the trial track, I will reach out to you. That's totally possible still, because a lot of judges still do that in a lot of districts.
Now, there's two other big points because one, I from what I'm gathering, this actually helps my case, and I wanted to talk about that with you for a second because if, a lot of people are out there ignorantly talking about we were late on filings, we didn't do this, we didn't do that. It's just false. If you actually go through the Florida docket, you'll see we filed everything and we immediately declared privilege, journalistic privilege, which is what we legally had to do. We didn't have to do a privilege log right away. We were arguing why we didn't need to have a privilege log. And that was part of our whole process. And in the hearings and transcripts, when we get them, everybody out there who's jumping to conclusions based on that order, you're in for an awakening because it's all in the docket. Don't just read the finale, read what we submitted. And part of what we submitted, Ron, and I've shared some of the notes with you, is the fact that we were the burden, right? And just the amount of the fact that Blake's case was sealed, the fact that we didn't even know what they had. And the judge was seemingly trying to make this like a urgent, a crucial part of this case, which I'm not. And so if anything, the way I look at this now, it feels like as Lyman's basically acknowledging, the volume of documents turned over in a way, it's too large to review. This is almost in a way helping me, right? And proving that she acted almost too quickly to assume that it was so urgent that my communications were central. The burden on me was minimal. I mean, as we're looking through this, as you just said, the burden to compile to this case is insane. There's so much to it. Do you see it that way too? Is this almost in a way proving the point of what we were trying to argue in that, like, Your Honor, there's way too much more to this to just immediately blanketly accept Blake's request for a non-party journalist to suddenly hand over private communication?
Yeah, you're alluding to a really good point. So when you as a third party were being asked to produce its own, for purposes, we'll just call it work product, your own private professional documents, the burden is high on Lively, right? It has to be really, really high. And there has to be a showing that of some form in order to satisfy, in order to breach into your privacy while not going too far. So most judges will really take that to heart and be intellectually honest and be like, this is a high standard person asking for these documents of someone that has nothing to do with their case. You have to meet it. And what it looks like happened is that this particular judge, in rushing, erred in the side of disclosure versus erring on the side of protecting your privacy, which I think is error, right? So, and I don't blame you for your feelings of frustration. I do think it was rushed through and not given the correct weight in the test that should have been applied to you, because a lot of it, everyone's flying blind, right? Like, there's just a lot of assumptions. Life is like, I say this and it's the truth, and judges like, well, she said it. It's really frustrating when judges kind of give the rubber the green to the other side when it should be the other way.
Well, particularly when I've done sworn affidavits and Lively's not said anything in this case and everything's under seal, right. It's a tremendous burden. So noted, I always like to hear your opinion on that, but also on the other side of this coin, from now going back to the case, there's this, basically there's a few things. Blake's sort of requiring sanctions, saying signal messages were deleted. Sorry, there's so many I think it's, I'm trying to figure out which ones are which. Here it is. Basically, yeah. This whole document here is trying to allude that, well, they knew they had messages. They deleted it, I guess, then before the trial was happening, though, arguing Signal self-deletes. The president uses it. Clearly, it's sort of a private communication model, but Blake's now trying to use as well. We don't know if they delete or not, but We know there was correspondence. It's no longer there. Signal must have self-destructed it, yada, yada, yada. Your Honor, we want spoilage sanctions to basically, from what I'm gathering, Ron, to prove they deleted stuff, which obviously affects, and we want that on the record when we're doing this in case to prove they did delete stuff and how troubling this is. At the same time, it's also of note, the judge is basically now compelling defendants to produce stuff within camera for Judge Lyman, proving he's taking some of this seriously, similar to mine. What's privilege, what's not. As you take all of this, I guess it's two sort of points. Let's start with the spoliation. Mm-hmm. If they're able to prove that Justin did delete, or Justin's team rather, deleted Signal messages, we don't know what those messages were, but is that enough to create a spoilage sanction? And that's a pretty serious thing, is it not? If they have to go on record saying, yes, some communication was deleted, could that actually harm Justin's case?
So it depends on, and it was unclear in the documents that we just saw. We skimmed earlier the reply. So it can, yes, but it depends. So there's two things that have to be done. The judge has to be convinced that the messages that are being sought were not preserved when they should have been preserved. Now, my understanding of Signal is that the setting is you send the message, it gets deleted automatically within a certain amount of time.
You could also self-delete, but yeah, it depends how the settings work, correct?
Depends how the settings work. And if the judge says messages, by the time you defendants were on notice that there was litigation, the obligation to preserve starts there. So once that's satisfied, as it happened. Two, did you take steps to preserve things reasonably? And again, if the settings are the settings, is that unreasonable not to change the settings on something that's, we don't even know the context of?
Well, and to add to it, like the retaliation campaign was over the summer before there was a lawsuit in place in the first place. Right. So if they were having deleted Signal chats during the alleged retaliation campaign, that's not them deleting evidence, is it?
Correct. Yes, that's a great point. And if that is where the focus of this quote unquote attack is, then I think the judge is going to be like, what's their obligation to preserve? They don't know they're going to have to need this later on an app where everybody uses, knowing that they're being deleted anyway. And then there's no finding of intentional destruction of evidence, which is the spoliation. Spoliation means intentional destruction of evidence. Now, what if the judge is convinced, going, yep, I see there's enough evidence for me to have a finding of an intentional destruction of evidence. What is the remedy for that? So the worst possible remedy is what we call an issue sanction, which is he makes a determination for the jury, going, these messages have to do with retaliation. So I'm making a finding that retaliation happened. Boom. Now that is an extreme example. Typically what happens is the judge will let the jury have an instruction. You were instructed to make the assumption as a finding of fact that the deleted messages were harmful to the defendant's interests, and that's why they were deleted. It's basically he's instructing them to do it, and it's not up to them anymore. That is an instruction. In your analysis of everything, these messages, jury, were intentionally deleted because they were not favorable to the defendant, and then make whatever assumptions past that. That could be an order that could be done. That's probably the more likely one that's extreme versus like an LR finding, a summary finding against the defendant. But that's what you want, right? Like, you don't want money. Like, it took me like 10 hours to write this motion. Like, I don't care about that. I want to win a trial. I want something to freak out the other side. I'm going to win a trial. So if the judge agrees with that and does that, that's a big deal. Like, that's a big deal to try. Yeah.
Right. And on now, second part with this fact of Lyman requesting in-camera review as someone now, before I even get there, because now I have more experience in this than I ever expected, Ron, of having actually someone who's now put in-camera review in this case and have it used against me and almost weaponized, which is not supposed to. It's kind of shocking how she revealed details of my in-camera review and flippantly. And so the reality is it's a good sign in a way, right? Because it shows the judge isn't just signing into the drama and taking everything Blake says at face value. He wants to see the evidence, right? But it could also be worrisome because even in mine, she misunderstood what she was even looking at. So what do you see when you see this, that he's now directing them to actually give specific materials in camera? Is that a good sign to you? Bad sign? How do you take it all?
Well, just like you, I think when you put your faith in the judge that they would do the right thing, it's putting the faith in Lyman that they're going to do the right thing. Now that Lyman's actually seeing these messages, these communications, these evidence, that one side is saying, listen, this stuff is privilege, it shouldn't even be disclosed ever. Treat it delicately because it may be a violation of civil rights if they get it wrong. So hopefully Lyman treats that responsibility with more temperament than what you experience, and really siphon things through. But this is the power of the courts, right? Like they make the decision. And once it's done, it's done. If it's exposed, it's exposed. They have no, you can't sue them for making a wrong decision. It's just, you could just appeal and hopefully it gets clawed back somehow. So this is the kind of awesome power that they have, in the sense that once they say something, that's it. Like they've made a decision. Hopefully it's the quote unquote right one, but at least one that respects both parties' rights and the third parties that are affected by these things, right? Like there's so much potential these ripple effects across the entire country in the entertainment industry, depending on what it is. Like every week I feel like there's another major celebrity involved in this. What was the last one I saw you talk about? The Rock. I was like, what's The Rock got to do with this? But who knows? You just never know.
Everybody's involved, and yes, all I can do is appeal. Guys, remember, you can help with appeal. I'm going to put the pinned comment down there. We still need your support. Ron, thank you as always. We'll be live later today with more, talk about a lot of the stuff that's coming in, so make sure you hit that subscribe and hit the bell so you get notified when it happens. Smash that thumbs up as well. Leave your comments down below. Ron, always a pleasure. We appreciate you being here so much. We got a lot more coming here on Popcorn Planet, so stay tuned.